Welcome to A Lawyer's Guide to the Galaxy, a podcast about geek culture by lawyers with your hosts, Ben Siders and Kirk Damon.
And welcome back to A Lawyer's Guide to the Galaxy, the podcast that asks interesting questions that don't have any answers with your host, Ben Siders, that's me, and the other guy is still Kirk Damon.
That's Kirk, as in the captain of the Enterprise.
We are intellectual property lawyers and certified geeks practicing law in St. Louis, Missouri. You can find me, Ben, on Twitter at Benjamin Siders, and you can find Kirk at KirkDMN. And today, we're going to get weird.
We are going to get weird. I think we need to call it before we get too much into our content. I'm just going to throw it out. Thanks on the Twitter shout out from one of our Star Wars sites that they're pointing out that we've been doing this for 5 years.
Have we really?
Yeah.
Oh my gosh.
I was kind of surprised to see that myself, but yeah, thanks for the call out in conjunction with that.
That's amazing. It does not feel that long.
Yeah, it doesn't feel that long at all. And admittedly, we only have, I think, 3 seasons in 5 years. But
yeah, the COVID year was a little odd. We've kind of morphed formats over the years. But anyway, the motivation for today's episode is that Kirk and I, last Sunday, went to a concert together. We saw the Weird Al Yankovic concert in Chesterfield. And we thought, you know what? It's about time we talk about this, because one of the most common questions we get, when you go to parties or when you meet people and you say you're a copyright lawyer, everybody wants to know, is what Weird Al does fair use?
Yep, and I think the interesting thing about this is the concert was primarily his original music, so it doesn't actually apply to the concert in many respects.
Well, we'll talk about this. At the end, he kind of mixed up the parody lyrics with original compositions, which we're going to explain why he gets away with that. And it's a lesson in not paying royalties unnecessarily. So we'll get into that. But the idea was to cover this topic, which we've talked about doing for really years.
Yep.
And we've kind of avoided one because music copyright is I've heard copyright, a lawyer friend of mine described copyright as just a psychotic area of law, which it kind of seems that way if you don't practice in it. But even for copyright, by copyright standards, music law is really complicated and difficult.
Yeah, and I mean, a lot of it's just because it's evolved over time, and quite frankly, as opposed to a lot of copyright law, it has evolved. And so that's part of the reason why you're having those kind of issues with it. But yeah, music introduces all sorts of weird things into copyright, because basically, as music has evolved from live music to, music of today, which, involves, using recorded music and making music out of it and stuff like that. The copyright law has evolved, and it's one of the few areas where it really has evolved to try to deal with these new technologies. But as part of it, when it's evolved to deal with those new technologies, it's created new mechanisms and schemes underneath itself, all of which you have to understand, and it hasn't gotten rid of nothing, but added a lot, and that's why it gets confusing.
Yeah, if you ever want to see an example of how laws used to be written, the Copyright Act goes into almost inhumane technical detail about how to calculate royalties and what the rules are, and trying to read, if you're trying to read the satellite radio sections.
Oh, geez.
Oh, my gosh. It is just, if you can't sleep at night, print that out and read it. That'll knock you out in no time. It is very detailed, and in a way that statutes are not usually written that way anymore. So we're going to talk about sort of the basis of fair use as applied to music, which is a decision from 1994 called Campbell versus Acuff Rose. Campbell is Luther Campbell, also known as Luke Skywalker with 2 Ys. Not that Luke Skywalker, the one from 2 Live Crew. They did a parody of Pretty Woman that sort of established the law here. But we know this is a little bit outside of our normal boundaries, but we kind of figure this is, if you're a Weird Al fan, you're probably a nerd.
It's Weird Al, you're probably a nerd. It involves Luke Skywalker. It's entirely in our wheelhouse.
Well, and then Emo Phillips did a little stand-up to open the concert Sunday, and even had a joke about how if you're here, you probably got bullied on the way to the concert.
Exactly, yeah.
So let's go over really quickly, or as quickly as we're capable of, which that's a low barrier. But we'll go over some basics of copyright and a couple of the music copyright principles you have to bear in mind to make sense out of all of this. The first one is, of course, copyright. As we always say, it's about what, Kirk? Copying.
Yeah, the right to make copies.
So copyright is not about attribution, although as a practical matter, that is important in a lot of these industries. But a lot of that is not for copyright purposes. It's more about who gets credit for things, who gets royalties for things. If you are named as the author on the work, then you have authorship rights, which means you have copyright rights. And generally speaking, it doesn't matter in reality whether you're the author or not. If you're recognized as the author, you get those royalties because that's just how the industry works.
Just as an example with that, I happen to catch this, and this is being a bit of a cynical, IP attorney. If you watched Ken Burns' documentary on country music, it's worth going back and noting in early country music, how oftentimes songwriters got added to early country music songs, those songwriters happening to be somebody at the record company. Do you have an idea why that might have been? That's the sort of thing with it. I point that out because it was when watching that as the cynical IP lawyer, I'm looking at it and going, oh, it's because they want to make sure they own the rights in this, which is not something Ken Burns ever says in the documentary. But it's one of those things that's it's an interesting sort of thing to think about. Is you do kind of bump into this where the attribution to who is the author is usually because of things in music that say that person therefore gets something out of being the author.
You see this in film a lot too, not to digress too much, but in film, getting credit as an author or a co-author, it matters for guild points, basically, your qualifications and eligibility to join the Screen Actors Guild or the Writers Guild or the whatever guild. So sometimes you'll see big fights over who gets credit for things. You probably, if you listen to this podcast, you've heard us say before, attribution doesn't really matter legally in terms of it doesn't get you out of the box if you're getting a copyright infringement. But being credited as the author does matter because it gets you rights. But it's not credit in terms of I can go print copies of Harry Potter as long as I say it belongs to J.K. Rowling. It's not infringement. No, it still is.
Yeah. So to use the extreme example, academic publications. Obviously, any of you guys who are out there involved in it, my wife's an academic, and so it's one of those things where authors on academic publications always point out the first one matters, the last one matters, and all the ones in the middle are because they need a publication.
Yep.
That's kind of the way the thing works, in many responses, in cases behind it. It's those types of things, and actually it's one that I have trouble with sometimes in patent law because we'll deal with things where they're giving me, here's an academic journal article that we want converted into a patent, and it's, well, who are the inventors versus who are the authors of the article?
Yeah.
Because you can readily be appropriately attributed on an academic article and not be an inventor on the patent. And so it's a matter of sort of keeping that straight. So again, we'll leave off on attribution, but it's just something to keep in mind that there's attribution issues out here that really don't affect the legal issues at all.
So let's break down songs. Music copyright is especially crazy because you've basically got two completely different and not entirely related sets of copyrights with music. I think when most people think of music, they're thinking of the things you hear on the radio or that you hear on Spotify, but that is actually two different copyrighted works. One is the song, which is in legal parlance is called a musical work, a term that's not actually defined in the Copyright Act. But the musical work is what we'd think of as a composition or the song in the abstract. But what you're listening to is both the song and a sound recording, a recorded performance of somebody playing the song. We had music before we had sound recordings, obviously. And so the law around musical compositions and the rights to them kind of grew up and evolved in the mid-19th century before we really had to deal with how do we handle people handing out phono records, which is recordings of people playing music.
Yeah, and I think the thing with it I always tell people is when you think about what is a composition copyright, it's the sheet music.
Yeah, that's the way to think
about it.
It's
the best way to think about it. Admittedly, the sheet music has a separate copyright in it.
It's literary work also.
Because it's also a literary work. But it's one of those things that's sort of the best way to think about it because there's nobody playing the sheet music, but it is the song. I mean, anybody who can read sheet music would recognize that it is the song and what the song is. So that's oftentimes the easiest way to sort of think about, what it is. But one of the first problems you always bump into in copyright is people thinking the sound recording is the work. And yes, it is, but it's only half the work. And that's the thing you really got to keep in mind.
And so for today's purpose, we're going to talk about parody. And obviously, if you're doing a parody, you're making your own sound recording. So you're not usually copying the original sound recording. You may be trying to make it sound the same, which you're allowed to do. We'll talk about that too. But you're not usually sampling. You're not directly copying the sound recording. And the copyright protection in a sound recording is very thin and really only extends to actually sampling or copying the song. So when it comes to the composition, we actually have a whole body of laws to govern making basically covers, which is where you're just doing your own performance of the song, maybe your own interpretation or take. But there are limits to what you can do even there. So a good example of that I saw last Friday before the Weird Al concert. We had Sammy Hagar in town, who, by the way, I've learned Sammy Hagar loves St. Louis, and St. Louis loves Sammy Hagar.
Yes,
I don't really understand why, but apparently that's the case. But opening for Sammy was George Thorogood and the Destroyers, and one of his best-known songs is Who Do You Love, which is not actually his song. It was written by Bo Diddley, but he played it, so he did a cover of his own cover at this thing. And then Move It On Over, which is a Hank Williams song, which he also did a cover of his own cover at the concert. So the important thing there is, although I paid money to go see George, Hank Williams gets money, or his estate, I suppose, for him doing the cover, and likewise Bo Diddley, because they own the songwriting and the composition rights.
Maybe not directly, depending on exactly how the arrangements are, but that's effectively they should be getting some form of a royalty.
In practice, songwriters assign their rights to what's called a music publisher. That's an old term that refers back to the sheet music days. But the music publisher manages all the royalty streams, takes administrative fee, and makes sure that you get paid for everything.
They basically determine how much each song is played, not each time it's played, but how much it's generally played, and then assign sort of all the royalties they take in on kind of a percentage basis, is my understanding how the things work, basically.
Yeah, pretty much. So we're going to talk about musical compositions, and as we said at the outset, copyright's about copying, and musical compositions are kind of weird because the laws of the United States first recognized a copyright in musical compositions not until 1831, by which point we had plenty of music out there, and even then it was only limited to copying sheet music. There was nothing about performances, certainly nothing about recording or streaming, because none of that existed. We didn't even have radio yet. But as technology grew and changed, the copyright law changed with it, and one of the most important developments is something we call the compulsory license or the mechanical license. Kirk, why do we have this thing?
Basically because it was difficult to administrate it otherwise. It's called a mechanical license because it relates to music enough to play your pianos.
Yeah, mechanical reproductions.
Yeah, reproductions, like truly mechanical reproductions.
It's an important distinction because it's one thing to say a person is performing the song, but the question was when a machine mechanically reproduces it, that's not the same as playing back a recorded performance. And so there was a question, if I'm selling the piano rolls, the pieces of the rolls of paper with the music, the holes punched in it, is that distributing a copy of the sheet music or not?
Yeah,
it wasn't clear.
And that's what you bumped into, is you sort of looked at it and said you have the person playing the piano. That's one thing we recognize.
They have to have the sheet music, or they have to have it memorized, right?
You have the distribution of the sheet music, which was the second thing, but now you have this roll, which isn't the sheet music, but incorporates the sheet music, but ends up producing the performance without the human.
Yeah.
And so you end up with this mid-ground, for lack of a better way of putting it, performance right.
Yeah.
Or mechanical right behind, the performance right being the human performing it, the mechanical right being this mechanical reproduction of the sound, not being performed, not being sheet music.
Yeah, the music industry basically said, no, you should have to pay for that. And everybody else said, no, we don't want to, because having a mechanical reproduction was way cheaper than hiring a piano player in your saloon.
Yeah.
So the balance they struck was to say, okay, if the song has already been published, then anybody can get one of these piano rolls to use in their piano. You can't tell them no, but they do have to pay you a royalty, which right now that royalty is 9.1 cents per song.
Okay.
Yeah, so it's not a ton of money, unless you're making a whole lot of piano rolls. But that rule is now applied to basically any time you want to record a cover. So if you want to, let's say you are Weird Al, and you want to do a cover of Smells Like Teen Spirit by Nirvana, you could just go record yourself playing that song. You can do your own interpretation, your own take. You could probably even do something kind of polka-ish, which Al likes to do. But the rule is it cannot change the fundamental character of the original, which is a really loosey-goosey standard in the statute. What exactly does it mean to change the fundamental character?
It's artistic statements. We're getting into sort of things like that. What does it mean if I record? I mean, obviously, if I go out and I record, Smells Like Teen Spirit, I am not going to sound like Kurt Cobain.
No, nobody
it's just
can.
The way it is, and so therefore, it is an interpretation of the work. It's going to sound different. I may speed it up. I may change its keys so I can sing it easier. Those kind of things are all acceptable. But when does it hit unacceptable and not of changing the spirit? Well, arguably, it becomes not the same song.
Yeah. A great example of that, one of my favorite Michael Jackson songs is a Billie Jean.
Yep.
And then Chris Cornell did a cover of that, which is slowed way down. It's much more melancholic. It's a lot slower and a little more, less of a dancey song and more of kind of a sad song. I'd argue that changes the fundamental character in some degree, but at the end of the day, it's still a song about the same thing.
Yeah.
Or, Elvis covered Big Mama Thornton song, Hound Dog. Very much changed the character. Big Mama Thornton's singing about cheating men. Elvis was just singing about a braying dog. So there's a lot of artistic flexibility in the statute in terms of how much you can get away with. But the terms that are relevant that it uses is that you can make your own arrangement of the prior song, but you can't change the basic melody or the fundamental character. And importantly, your arrangement is not a separately copyrighted derivative work. It is just your arrangement. So you don't get any rights to it or anything like that.
And part of the thing, I think the reason we had this stuff is because arrangements are recognized as derivative works, and so we kind of had to deal with that around the statute. That's an older version of the statute. We now had to deal with that with this recreation of mechanical licenses related to sound recordings. This was my comment at the beginning. Music has evolved.
Yes.
In conjunction with copyright, you're seeing this evolution, this addition of stuff to it, but there's also a recognition of all the underlying stuff is still there. And that's part of the reason this gets complicated.
Yeah, and I mean, the modern set of rules and regulations and laws around music really didn't fall into place until like the 70s.
Yeah.
That's when we had the first recognition of the sound recording right. And even then, it only applied to new stuff. So old sound recordings were still governed by state copyright law up until about 5 years ago. Like, it's kind of crazy to think about that. Let's talk about the Two Live Crew case, because this is where the idea comes from that we hear this a lot. Oh, parody's always fair use, right?
Yeah, well, I think that comes from the fact that people know that parody's out there, and that parody is a fair, the nature of the work, parody is a fair use standard. People oftentimes have bumped into that. The thing that you bump into with it is it's really not. When we think of sort of, there's parody, there's commentary, there's these kind of things sort of with it. There's also just making related funny songs.
Yeah.
What we oftentimes think of as a parody song is not actually a parody inside the law.
And we're going to get into that because that winds up being an important consideration in how we look at what Weird Al does and how he does it.
Yep.
So let's talk about the Two Live Crew case. You probably all know the song Pretty Woman. If for nothing else, then because you've seen the Julia Roberts movie, so named. Pretty Woman was written in 1964 by Roy Orbison and William Dees. They transferred their rights to the music publisher. Like we said, you usually have somebody administer these rights for you. A publisher called Acuff Rose in Nashville, of course. Even back then, we're in Nashville. Like we said, the publishers are rights managers. They handle your licensing, royalties, that sort of thing.
And Roy Orbison did record the song.
Yep.
I don't believe Dees was involved. I think he was just the sound.
I think it was sound engineer or additional songwriter. And then the Acuff Rose is gone. Everything now belongs to Warner, Sony, or what's the other one I'm forgetting? Universal. Maybe? Yeah, so there's like 3 publishers left now. So Acuff Rose now is part of Sony Music. But in the 1980s, a Miami-based rap/hip-hop group rose to prominence called Two Live Crew, which you've probably heard of, I would guess, most people.
Anybody sort of our age, you've definitely heard of Two Live Crew.
Definitely.
I mean,
our parents all hated Two Live Crew.
They were a major band, for us as kids. It's whatever it is. Nowadays they're falling out of prominence, I think a little bit, but they're still. If you don't know who they are, you probably should learn a little bit about them and listen to a couple bit of their music because it was very influential.
It was influential. Our parents would say for all the wrong reasons. Of course, we all thought it was amazing. But so the members, the best known lineup was Luther Campbell was the front man, better known as Luke Skywalker with 2 Ys. Christian Wong Wan, whose stage name was Fresh Kid Ice. Dave Hobbs, whose stage name was Mr. Mix, and Mark Ross, whose stage name was Brother Marquis, or Marquise. I'm not sure how he pronounces it.
I think it was Marquis.
It was Marquis, yeah. They were very controversial because their lyrics were very explicit, particularly by 1980 standards, maybe a little tamer by modern standards, but they were considered, shall we say, bawdy at the time. So Campbell wrote the lyrics to this parody of Pretty Woman. You can look this up. The lyrics are very different. They start out with kind of what I'd call a sort of hip-hop play off the same basic idea of meeting an attractive woman, and then they quickly degenerate into
a bunch of sexual references.
A bunch of sexual references, and then at the very end, he's just grateful that she is not having his baby. So it's a very different song, and I think you would have a very reasonable argument that under the cover band law, it is a change to the fundamental character of the song.
It also really doesn't share the music as well. I think that's an important thing to sort of keep in mind. This is a hip-hop song, Roy Orbison's old school rock and roll. We definitely have a different style of music here. Now, we're going to get into some of the specifics of the music, but it's definitely a different style of music.
In any event, the lyrics are different. So even if it's in the same, even if you could consider it to be the same fundamental character, the lyrics are completely original and different.
Yeah.
And so it probably is not going to be okay under the cover band act. So they're not. It's not a cover. It's definitely a parody. And Two Live Crew did what you should do in a situation like this. They contacted Acuff Rose and said, "Hey, we wrote this. Can we license the song from you and put it out?"
Now, why did they want to license the song? Let's point out the fact that there's a certain reason why they wanted to license the song.
Yeah.
And that was because of the fact that they were going to use some of the same guitar and bass riffs in it. So It's not that they completely rewrote the music. There is elements of the original Pretty Woman music in the song. Now, it's not entirely the same, if I remember correctly, but there definitely are elements of it, and there's elements of it that are recognizable to the average listener. Like, this is not something which is hidden. This is not, two random notes that only, somebody studying music theory would ever get. No, this is pretty apparent.
If you heard I listened to it the other day, if you listen to the first 5 or 10 seconds of the Two Live Crew version, you'd recognize the song, and you'd also immediately know it's not Roy Orbison.
Yeah, exactly. And I think that's a good way to think about it, is you've got the similarity, you've got an immediate recognition, but you also have an immediate recognition that it's not the Roy Orbison song.
So they said, we'll give Acuff Rose credit as owning the rights, we'll give Orbison and Dees credit as the authors, and we'll pay a fee. And they sent them a copy of the song and said, what do you think? Acuff Rose said, no.
It was probably closer to hell no, I guess. But
they said, we're not doing that. Sorry. Actually, they may not even said sorry, but they definitely said no.
Yeah.
Anyway, so Two Live Crew said fine and launched it anyway. Yeah. And after it sold about 250,000 copies, Acuff Rose filed lawsuit. Didn't even get to a jury. At the trial level, the trial court said, although the use is commercial, which normally kind of weighs against fair use, it doesn't mean it can't be a parody, and in this case, it seemed like it pretty much was a parody, and so they ruled against Acuff Rose on that basis.
Well, one thing I think to keep important in mind here with it is, we've said on sort of fair use, parody is not really a factor of fair use. It's the nature of the work. The thing you really kind of get into here in some respects is it a commentary on the original work?
Yeah.
And I think in some respects that's what they're saying by being a parody. It is, as I said, they're both about Pretty Women. They're very, very different portrayals as to what it is. As we said, it's very sexually explicit lyrics, sort of things like that. But it's also the fact that it kind of was, I'd say, arguably pointing out differences in time, which is probably part of the reason why the music publisher was saying no in it, is because he didn't really want the Roy Orbison song, which is this kind of classic, wholesome, old-school rock and roll song, associated with this, what is now hip-hop, and at this point in time, a edge genre. I mean, it's not really reached the mainstream, which was known for potentially being, having violent lyrics, having sexually explicit lyrics. They don't necessarily want to be associated with this. So we have the reason this is probably resulting in the fact is because, hey, they asked for the license. Now, they could have granted it, but they didn't grant the license because they ultimately didn't really like the song.
Yeah, they probably just didn't want it to come out.
Yeah, they didn't want it to come out. But now it comes out anyway, and the defense is, we can do this because it's parody, because it's fair use.
Let's talk about the fair use factors real quick. There's 4, basically. Yep. The first one is the nature and character of the use itself that you're making. Yep. And the key inquiry there, if you remember our Warhol our last episode, is basically how transformative is it? Are you just repurposing the original for the same thing, or is your new use transformative in some different artistic direction in some way? Yep. And parody is generally recognized as being very transformative.
In this case, it sort of is a parody. There's some argument, I think, that this is a commentary on the original song, or at least the time period.
That was the argument,
song.
at least. Yeah. The second factor is the nature of the copied work, which in practical terms almost never makes any difference at all. The one big exception to that was Google v. Oracle, where the fact that it was software did make a difference. The third factor is how much did you take, and the part that you took, how important is it to the work? We went over that in the Warhol case. Kind of a mushy standard too, because there's sometimes you can take what they call the heart of the work versus which may be a small piece of it.
This was probably taking the heart of the work, even though it was a relatively small piece, because again, it's immediately recognizable.
Yeah, you have to recognize it. So if you're not taking the parts people know, then what's the point? And then the last one is, and this is generally regarded as the most important factor, what is the impact that the fair use version is going to have on the market for the original?
And is it commercial or non-commercial presentation? So if you are a commercial work, fair use is much harder to get, as the later work. Because the fact that you are essentially a direct competitor. So why should you be allowed to capitalize on them as a competitor because you're making money from it? The person should be making money from it instead that originally came up with it. And sometimes considered the most important. In this case, unquestionably a commercial work. Like that factor isn't even going to come into play here. That one's obvious.
Well, it gets sloppy too, because the commercial versus other use question is technically part of the first factor, the nature of the use, but it winds up being considered in the fourth one, and it kind of, the courts always get mixed up on that. Like where do we consider that? Do we do it in both? And you kind of get to in the first factor we say, and we're going to get to this, what the Sixth Circuit said. Often you get to the first factor and say, well, it's a commercial use. So I don't care how transformative it is. You're competing with them, right? So it's not okay. And that is what happened here. On appeal, the Sixth Circuit, again, we're in Nashville, so kind of an unusual case to come out of the middle of the country, found that while the song was a parody, they said every commercial use is presumptively unfair. Citing for that proposition, another fair use case, Sony versus Universal Studios, 1984, the VCR case.
Yes.
Now, the facts in the VCR case were different. It was copying the entirety of the thing for the exact same purpose.
Yes.
So that case had some different facts. But the Sixth Circuit also said, you know what? Although they didn't copy everything, they did copy the heart of it. They copied the memorable bass riff that opens it up. And then they said, you know what, as far as the harm, the district court had, I think, correctly said, we're skeptical that Two Live Crew is going to have any significant impact on the demand for the Roy Orbison version. But the Sixth Circuit said, we're just going to indulge a presumption of harm because it is a commercial use. Getting back to that whole mixing up of the factors thing. So Two Live Crew, understandably dismayed by this development, appealed to the Supreme Court, who reversed.
And quite frankly, I think this is an interesting thing to point out. It's good that they did this.
Yeah.
Because if you really look at it, this is the early days of hip-hop, and this is kind of what this hip-hop and rap music was about.
Yeah.
We now have this case going to the Supreme Court sort of saying, is this okay? So there's almost a sort of music history argument that there's a reason why virtually every lawyer has heard of this case, even if they aren't an IP lawyer. This case was very important to the world as a whole.
Yeah, because if this doesn't come out in their favor, it cuts off a lot of the stylistic, and I'd even say sort of the cultural elements behind rap and hip-hop music, which all grew out of like live DJing, where you don't have these problems.
Yeah.
You just get, one, you're just playing music, that's already recorded, so you don't have to worry about that side of it. But, you get a PRO license and you just spin some discs and whatever, it's fine.
And even when you're modifying, you're doing it all live, it's performance rights. And so, the thing you're bumping into with this, and I think that's where we really saw this is sort of the evolution of copyright. The problem here was we have this type of music growing out of live music where copyright basically says, no, this is all fine. And everybody agrees it. As soon as it starts getting recorded, it's like, no, wait. That copyright doesn't say that's fine. Yeah. And so now we've got to try to either shoehorn it in under something else or we've got to newly deal with it. And the answer is that we're going to newly deal with it. That's what we're going to deal with here.
And I should say, by way of an aside, I was in Nashville not too long ago, and Kirk had recommended that I visit the National Museum of African American Music History, which I did. It was phenomenal. Yeah. Kirk's recommendation was excellent. If you're ever there, I highly recommend it. And they went through all this stuff, the evolution of hip-hop from the DJ scene all the way through this. I think they had Flava Flav's drumhead there, like of all things. It was really bizarre to have. But it was a really neat presentation that gets into a lot of the evolution of this type of music.
Yeah, so I think a lot of our background we're going to say is, in conjunction with this, that's what we're basing this on from, is what we learned at that museum. And I'll go ahead and put it out here as what it is. That is probably in my top one or two museums in the country right now.
Yeah, if I go back to Nashville, I was only there for like 2 hours. I could spend an entire day.
Yeah, that museum is utterly fascinating.
Yeah. Okay, so Two Live Crew appeals to the Supreme Court, and they reversed the Sixth Circuit, siding with the district court that said it is a fair use. I'm not going to go through the whole opinion, but we'll go through the fair use factors really quickly. They said, it goes without saying, this would be an infringement, but for fair use, which is an important thing to recognize. And then two, really the most important thing they said is the Sixth Circuit made a mistake in that they're basically trying to apply these bright line rules. That it's presumptively not a fair use if it's commercial, and we're going to assume harm if it is commercial. So basically, once you're making money off of it, we're just going to assume two of the factors weigh against you. Well, considering there's only four factors, and one of them never plays any part, you pretty much always lose on fair use.
And quite frankly, this is a very Supreme Court decision, which is basically the we hate bright line rules.
Yes. Yes, which also is, if you ask any copyright lawyer, is it a fair use or not, they're always going to fall back on, well, it's a very fact-specific contextual inquiry, and this case is why.
I have that discussion almost every day.
So on the first factor, the court said parody can be transformative even if it's commercial. And in fact, parody supports the reasons why we have copyright in the first place, but, and this is important, it must actually be parody, which means it must be a commentary or criticism of the work being parodied, and not a satire, which is using the work to make fun of something else. No. Which will matter a lot when we get into Weird Al, because a lot of his parodies
is he a parody
aren't
or not?
Really parodies. Yeah.
And the thing to keep in mind about this actually, I believe, arose out of an earlier case having to do with a play I remember correctly, that was determined to be satire and not parody, and that was important in the determination. So there's a reason why the Supreme Court is making this statement. The idea that parody and satire are different, that parody under fair use means you are making fun of the underlying work.
Yeah.
And in this case, if you go and you listen to the Two Live Crew work alone, I'm not sure you're necessarily going to say it's making fun of the underlying work. At the same time, if you look at it, you look through the sort of what the band said, the brief, according to the briefs in the law court and stuff like that. There's a very legitimate argument that the purpose of the song was to be a parody of Roy Orbity, which, quite frankly, may be why they didn't want to grant them a license to make it.
Yeah, they probably saw that coming. So Campbell, Luke Campbell, the author, he later described the purpose as to satirize the original work through comical lyrics. So, which, if you read the lyrics, they are kind of funny. I mean,
they are kind of funny.
Pretty tame by modern standards, but at the time, it was, like I said, the kind of thing that made our parents, want to burn our CDs, throw away our record players.
And our parents clearly never listened to country music at the time, because then they would have been really horrified.
Oh, yeah. So anyway, but interestingly, is and we got into this with the Warhol case a little bit. Who gets to decide if it's a parody or not? Isn't that really an artistic assessment? And the court here acknowledged that they are not the right people to go ask, is a Two Live Crew parody of a Roy Orbison song a parody or not? Basically, if you can find some straight-faced explanation for why it is, they're just going to assume that it is, whether or not that was actually the intention, which is, of course, debatable. Easy to say after the fact.
Yeah, if you want to get into the discussion of that, we have a pretty big discussion of that in Warhol about the question of, what does an artistic statement mean in conjunction with, generation of the work. That case, it would have to do with what is is it transformative or not? What's the transformative nature of the work? But it's the same thing here. One of the things the courts have real trouble with is, if we need to evaluate, is it art? We're not really good at doing that.
We're not the right people to do that. Even the jury really shouldn't be doing that. So this is the fundamental tension in copyright law, is we're balancing. We have a law that has to capture on some level making artistic judgments, and boy, are we terrible at doing that.
Especially as lawyers.
Okay, so the second factor is the nature of the copied work. This factor, like I said, almost never plays any role in the analysis, and it played virtually no role here. Third factor, amount used. The court said, yes, we have this whole goes to the heart of the work thing. That goes back to a case involving Gerald Ford's memoirs. But they said in parody, it hits different, right? Because if you don't copy the heart of the work, then you can't really do parody.
Yeah, you can't really do parody. It's not funny unless you know it's the work.
They basically said if you don't recognize it, then you're not parodying it. You're just making a different song. We'll talk about that in a second, because Weird Al plays in here with how he did his concert at the end. And then the fourth factor, they said you cannot have an evidentiary presumption of harm, especially if we have a parody, which is inherently transformative. They said the main harm a parody might cause is that if it's an especially good parody, the criticism may be so biting and devastating that nobody wants the original anymore. And they were like, but if that's the case, fine. That is not the kind of harm copyright's meant to deal with.
That's what the First Amendment is supposed to allow.
They said basically, which is interesting. So we have a Supreme Court saying if you can kill something competitively through parody, you get to win.
Yeah, exactly. But again, I think it's a very legitimate argument, which is the whole idea that basically says, if you are such biting criticism that nobody wants to read the original, we want that type of criticism because clearly it's correct.
This is the reason we have a Copyright Act in the first place. This is to encourage people to create new works. So, the court went through the factors and basically said, no, Sixth Circuit, you got it wrong. Importantly, though, what they did not say is that your ruling that it was not a fair use was wrong. The way you got there was wrong. You used incorrect assumptions and an invalid illegal analytical framework. And so what they said is, here's the correct framework, now go back and do it again.
And the real key about this is the phrases that you hear repeatedly in legal circles: reversed and remanded.
Yes. For further proceedings consistent with this opinion.
If you want to write the rest of it. Reversed means that the judgment has said, nope, the judgment was wrong.
Yeah.
You found for the wrong side. But instead of saying, we find for the other side, they said, no, we told you what you're supposed to do, now go do it.
Yeah. Now, it is entirely possible that there's a universe in which the Sixth Circuit picked this up and looked at it and said, okay, even under this corrected framework, Acuff Rose still wins, and Two Live Crew still loses.
We are not driving the Marvel Cinematic Universe into this, so I didn't stretch the imagination. But yes, there could be parallel universes in which courts actually find things.
But that's not what happened because Two Live Crew and Acuff Rose settled. So it never actually went to a judgment. The press reports at the time said that Acuff agreed to dismiss its lawsuit, and Two Live Crew agreed to license the parody, which is what they wanted to do in the first place. So Acuff ended up getting some money out of it, and a bunch of lawyers got paid in the meantime to go through what had to have been a really fun academic exercise in arguing this.
And to keep in mind with it, just with the injunction of these cases, we mentioned it. If you go to law school and you do any form of Supreme Court law, any form of IP law, this case will be in your casebooks.
Yeah,
this is one of the most major cases. If you study one copyright case in law school, it's this one.
Yeah, there aren't a ton of Supreme Court copyright cases, period. There's even fewer fair use cases. Yeah. And when you cite to them, there's the Folsom case, there's the Sony case on VCRs.
Yeah, Betamax, technically.
Yeah, there's this one, and then there's Google v. Oracle. Those are the cases. So that does not get taken up a lot, although we're about to have another one. Warhol is coming too. So, I don't know, the court must be bored because they're taking up a lot of these now.
I still think the Warhol case is because there is no good answer to this, and this is the kind of case that, quite frankly, the Supreme Court should rule on.
Yeah, that we need some clarity here. Also interesting here, this case is sometimes incorrectly cited for the proposition that parody is fair use. I think it's more accurate to say it held that parody can be fair use.
Yeah.
Might even, parody usually is fair use. Wink, wink, nudge, nudge. Lower courts. Yeah. Stop throwing these out. The framework established by the Sixth Circuit would have basically made it impossible for a parody to ever be considered fair use. And so for the Supreme Court basically came in and said, not so fast, and paved the way for all these parodies going forward.
And again, I kind of joke about the fact that this is kind of your stereotypical Supreme Court case. One of the things you rapidly learn about the Supreme Court when you study Supreme Court jurisprudence is the Supreme Court loves to basically say, lower courts, stop simplifying everything and making per se rules. It's all vastly more complicated. You need to go through the more complicated analysis, so do so.
Yeah.
And that's basically what they do here, with it, which is also, again, part of the reason why this is such a seminal case is because it is the copyright one that says parody is fair use, which would actually be relatively uninteresting.
Yeah.
It's that parody may be fair use. Here's all the legal analysis, which is why this isn't a case book in law school.
Yeah, exactly right. And I think maybe they were motivated a little bit also by the desire to soften and maybe walk back a little of the language in the Sony case, which we'll cover that case at some point too, because it's also a really interesting case about time shifting.
That was whether or not you could have a Betamax, VCR now as we think about it, but Betamax was the competing technology because it copies what's on TV, and without that was allowed. And that's one where you can pretty much see the court saying, we want this technology to exist and we're going to find a way to justify it. So arguably, this is one of those where they kind of walked back the justification to say, no, we didn't mean it quite that, absolutely.
Yeah. So, we got a settlement, never got an actual ruling on whether, as a matter of law, this is or is not a fair use. We just got a settlement. But as typically happens in a case like this, everybody who knows the law here can read this Supreme Court case, see the writing on the wall, and realize, okay, we're not going to win a whole lot of copyright infringement lawsuits against people who are making parodies of our songs. Yep. So for all practical purposes, parodies are generally going to be considered a fair use, but we should say it is conceptually possible to make one that is not.
Yeah, and I think let's get into the thing with it here, and I think a good place to go next is what's a parody song?
Yeah.
And, we had in this the comment of, in the Supreme Court said in this, it's a parody song because effectively it's making fun of the underlying work.
Or at least commenting on it in some way.
Or commenting on the underlying work. There's not a lot of parody songs that actually comment on the underlying work.
Yeah.
A lot of them are actually commenting about other things in society.
Yep.
Or commenting about the music industry as a whole, things like that. Does that mean it's not really a parody, it's a satire? Because under Two Live Crew, we have them making a very important distinction between parody and satire. Again, based upon prior case rulings having to do with satire not being considered fair use.
And the same distinction exists in trademarks, we should also say. There's a trademark fair use doctrine for parodying a product. But satire doesn't always work the same way.
Yeah, and so I think we've got some of the things with that. And when we then get into, and this is what we're going to sort of talk about specifically in conjunction with Weird Al, are his songs parodies or are they satires?
That's a good question. So let's talk about Weird Al. What's interesting is that this case, Campbell versus Acuff, the Supreme Court decision came down in 1994. Kirk. I remember Weird Al in the 80s.
Oh, yeah.
Don't you?
He was definitely around in the 80s, no question behind it. Now, he existed before this was ever a question. And I don't know, quite frankly, how many artists there were who did his style of music before he did it. He's definitely one of the, probably the most famous person doing that style of music.
We should say also, I couldn't find it. I've got a copy of the case here in front of me. I was trying to find this quote that I remember reading a long time ago. Somewhere in the Supreme Court case, they say, you know what, there's not going to be an impact on the market for the original. Who could ever maintain a career making parody songs?
And yet we have, but as Weird Al himself even commented about, 40 years later, I'm on a tour bus with this comedian. Who would ever thought my life would turn out this way? And as he pointed out, probably me.
Yes, of course.
Which was one of his better jokes. But yeah, it's one of those things with, what we really have with this is what we have this kind of thing of there's a key aspect, again, I want to get into of the Supreme Court, which is this type of music was not that old. At the point in time this happened. It's something we look back and say, this is old school music, this is 80s music, 90s music.
Particularly in popular conscience. I mean, the hip-hop scene has really older roots, but, in terms of getting, like, mainstream radio play, Two Live Crew on your FM radio, that was relatively new.
Yeah. And they never really played this song because of the issues with the lyrics, if I remember correctly.
I don't remember this one ever being on the radio. I remember other songs of theirs,
But it's one of those where, you have this kind of thing with there's a recognition, I think, in some respects by the Supreme Court, even though they never voice it, of music is changing. We have this sort of thing where it basically says, hey, there may be more parodying, there may be more around this. We have Weird Al Yankovic, we have other, artists out there that are potentially making parody and satire songs. We don't want to just say you can't do this, as a flat-out thing, which is what the Sixth Circuit said. We're going to say it depends.
Mm-hmm.
So when it comes to Weird Al, we look at it and say, well, what about his songs? And we were having this discussion. Most of his songs do not appear to be true parodies. They're not making fun of the underlying song. As we said, and we picked on the beginning, Smells Like Nirvana is clearly making fun of the song Smells Like Teen Spirit.
The video, it's all making fun of the unintelligibility of Kurt Cobain's lyrics. But yeah, most of his songs don't do that. I mean, there's nothing in Eat It that is making fun of Beat It or Michael Jackson or the song. The video kind of lampoons it a little bit, where they're like knife fighting with rubber chickens or whatever.
But let's take over an entirely different one. Like a Surgeon compared to Like a Virgin by Madonna.
Yeah.
Those have nothing to do with each other.
Yeah, no, definitely not. But you get borderline cases like White Nerdy. Maybe almost the inverse of the Campbell case, where he's making fun of the hip hop image by talking about the exact opposite thing.
With the MIT.
Some guy mowing a yard in his loafers.
You have those kind of things sort of come in. Similarly, Amish Paradise to Gangsta Paradise.
Yes, arguably some parodic elements there.
Yeah, but I think what you're seeing with this is that we have this problem of, well, is the song a parody or is it a satire? This is something the Supreme Court said is important. Yet we also notice this hasn't really been fought over.
Yeah.
There's not really been any cases of, your song's really a satire against, the vagaries of Nashville's music industry and not making fun of my song as a whole.
Yeah.
No, we haven't had that.
Had that battle. And there's a simple reason why, which is Weird Al does the exact same thing Two Live Crew tried to do.
Yes.
Go get permission.
The difference with it is I think he's usually given it.
He usually does. There's a couple of cases where he did not. I was actually looking this up after we saw the concert. Like has anybody ever told him no?
I thought there was at least one famous case.
Yeah, there are a handful of people who've told him no, and almost all of them have later regretted it. I think there's one artist, I think Prince was the famous one, that absolutely would not give him permission.
Okay. And that's, again, some of you can see as to, this is, artist prerogative. But at the same time, the other thing to keep in mind with Weird Al is he has honored that. He has not released a song saying, I can release this because it's parody and it's fair use. If you say you can't make parodies of your songs, he doesn't.
Yep.
At the same time, I believe certain artists as well were actually kind of flattered by his.
It's become a thing now. Like, if you ever read his Wikipedia page, the number of artists who have been like, "Oh, I was so excited when Weird Al called me." That means I've made it. Like, that means I've made it. I'm relevant enough to be parodied.
To be parodied, and I mean, quite frankly, he's got a point.
Yeah. Well, we should say also, the concert Kirk and I went to, though, was not a parody concert. He played all original stuff.
I'm going to get the name of the concert wrong, but it's the return of the ill-advised reading tour or something like that.
The ill-advised egomaniacal something, where he's playing all of his originals, none of the parodies. But what's fun, though, is a lot. I mean, even his original songs all are kind of in a style. So, what did he open up with? It was one I hadn't heard before. Why does this always happen to me? Yeah, which I don't know what style I would call that, but it was kind kind of a generic bland pop song.
Yeah, I think a lot of, quite frankly, his generic pop songs, his generic made fun of songs, they're very 80s, I think, because most of the ones he wrote in the 80s period, they have that, and the adjective I always use, which is my own selection of it, is they have a very plastic sound.
Yeah.
So I always refer to 80s music as sounding plastic.
Yep.
The thing sort of, with it, and that's a lot of his are that. The one that we really were pointing out, and I had to explain to my kids, is at the very end, he did Nature Trail to Hell, which if you've ever heard the song and you know what it is, in some sense, it's lampooning the fact that there's a window in the 80s when every horror movie ended with "to hell," and that was bus ride to hell. And it's the more recent example of it is about question Sharknado and Sci-Fi Channel sort of making fun of what things can be mushed together and make into funny horror movies. It's that same kind of idea that was happening in horror movies at the time, and that's what he's doing. He's making fun of it by saying, "I'm going to make this grotesque, essentially." The song, which is about a grotesque movie trailer, which is Nature Trail to Hell, and in 3D, and just making fun of the way these movies were portrayed. Horror movies were portrayed at that point in time, and slasher movies in particular.
Yeah, a lot of his songs are like that. Like "Dare to Be Stupid" is one of his most famous songs, which is like a very 1980s like Euro music type, I don't know. You know what it reminds me of is the Mike Myers sketch on Saturday Night Live, Sprockets.
Sprockets.
But he's the welcome to Sprockets. It reminds me of that.
That's a perfect example of what it's like. Yeah,
just kind of has that sound to it. If you don't know what that is, go Google it. It is worth your time.
That's one of Saturday Night's betterments ever.
Yeah, kind of obscure now, but really good. So he does a lot of these sort of mashups. He always did his polka medleys on each album. Yeah. Now the polka medleys are covers.
Yeah,
those
are usually.
Yeah.
He sometimes alters lyrics slightly.
A little bit, but not much. But that happens anyway in covers. That's the thing. Like, the literal language of the cover band statute basically says you can't change the fundamental character. But like I said, the Chris Cornell version of Billie Jean hits different. It's just a very different song. And a lot of these songs will change up how it sounds and how it feels when you do a cover.
The best example of picking on him for the polka is if you want a great polka, and I think, and my kids love it, and I think it's hilarious, his most recent release is the Hamilton polka.
Yes,
he takes the music of Hamilton and releases it as a polka. It is utterly hilarious. Watch the video as well.
My kids didn't even recognize the songs at first until they got to the one that King George sings.
Yes.
The rock ballad love song. They're like, oh my gosh, that's this song?
Exactly. But yeah, it's the perfect example because he basically keeps Hamilton. It's unquestionably recognizable as the Hamilton music, and it's also a riot because the stuff is a polka.
Let's talk about what he did at the end of this concert. When he got done with the original. So I had to leave. My kids weren't feeling good, and they had to get up early. So Kirk got to stay for the end of it and got to see my favorite Weird Al original, The Biggest Ball of Twine in Minnesota. But Kirk,
they pointed out it was not my favorite, which was actually Midnight Star. They did about halfway through the concert.
Yeah, and Frank's 2,000-inch TV is another good one. But they at the end he didn't do the parodies, but what he did do was perform original music set to the parody lyrics.
Yes.
So this is interesting because the lyrics were written in the style of like let's say Yoda, okay?
Yep.
So
he did White and Nerdy, he did Amish Paradise, he did Yoda, and he did Word Crimes. He may have done a couple others.
Word Crimes is phenomenal.
But he did not do them with the underlying parody music. He did them to entirely different works of music that he sang those lyrics over.
So he would be the author of the lyrics to his parody songs.
Yep.
But so if he puts those lyrics to different original music, then it's no longer
presumably not the parody because it's an original song.
Yeah. So then he gets away with not having to pay royalties on the songs he's parodying because the music is original and the lyrics are original.
Yep.
So yes, a very, very interesting exercise there, and him being able to do it all because technically it was all original, everything in the concert.
Yeah, and I'm assuming in conjunction with this, and just so I actually listened to it from outside the venue because my kids were also needing to leave. But when we heard him starting to do his encore, we left immediately before his encore started. We heard him starting to do the encore, and we heard what it was. We actually stopped and listened to quite a bit of it. He did this all as a medley, and it went for about 15 minutes. Wow. He actually did quite a bit of sort of stuff in the middle of it. And he did some sections in the middle of it because I couldn't see him. I didn't know what he was doing on stage. So I can't say a lot about that. But it was one of those things where, it was very interesting to hear them. And of course, as soon as I heard it, my immediate take was he's doing parody lyrics over original music. He's not licensed to play this venue to play the parody songs. That's how he's getting around it.
Yep.
That's the immediate take. Again, as an IP lawyer as to what this is, great idea.
Oh, yeah. Which also one more thing I want to mention. When he did Dare to Be Stupid?
Dare to Be Stupid.
That he did as like elevator lounge music. Like he completely changed the genre.
He laid it out as lounge fairy music.
Yeah.
I would call it Muzak. I mean, which really, that is a trademark. Muzak.
No, it was like waiting for your orthodontist appointment music. It was so terrible.
And that was the whole point, is that the audience was sitting here going, "Oh my God, this is a song we all know, we all kind of love."
I didn't recognize it at first. I'm like, what is he playing? And then Kirk looked at me and I was like, "Oh my God, it's Dare to Be Stupid."
Well, and the funniest part of it, of course, if you know Dare to Be Stupid, he has the section in it where he's like, yell out to me, Dare to Be Stupid. I can't hear you. And of course, the audience is yelling, Dare to Be Stupid. And then the next line is, okay, I hear you now. And well, of course, the audience did that, but they didn't really know how to do it.
Because it's not the same song. Yeah. Oh, it was great. So there you go. There's sort of the nuts and bolts of it. It's Weird Al is actually, in some sense, a less interesting example than maybe it sounds like, because it's part of sort of his business ethics as a performer.
And business acumen, quite frankly.
Yeah. He's managed to. I mean, think about this. Weird Al got his start in the 1970s, so he has been active and successful now in 6 different decades of music: 70s, 80s, 90s. That's six decades. Still relevant, and it's all the more ironic that in this Supreme Court case that kind of paves the way for this. They're like, who would ever make money off this anyway? Like, you can't build a career off doing this. Well, one guy did.
And there's some of the other ones out there. There are well-known parody artists out there as well. He's by far the most famous, and part of it's because he makes fun of pop music.
Yeah.
So he's
another good one is Richard Cheese. That's a stage name, but he basically does true parodies, but he does re-performances of like famous songs, all done in that same like 70s lounge, like fairy lounge type style. And it's very distinctive. And he also likes to pick songs with extremely explicit lyrics and then sing them in this lounge lizard style where it's very juxtaposed. And again, arguably altering the fundamental character of the song, but this is one of those things where, you know what, you're getting paid the royalty off of it, so what do you care?
One of the funniest ones,
you're 9.1 cents per song.
If you want to think about funny ones, Stephen Colbert actually did a number of sort of parody lyrics and stuff like that. He has a parody album of Christmas music. My favorite one of which is he actually does Angels Will Be With You Shortly, which is about being put on hold to hear your prayers. And one of the most hilarious portions of it is you get the Christmas song "Angels We Have Heard on High" done as hold music, which is really pretty hilarious. But yeah, it's one of those where you have a lot of parody, you have a lot of this kind of stuff going down. Weird Al did, I think, without any question, pave the way. But Weird Al is a completely uninteresting case in this because, well, he's entirely licensed, which means everything he does is legal.
Yeah.
So from our point of view, this is legally uninteresting because it's all okay.
Yeah, it's one of those open and shut, close the book on it type deals. Where how does he get away with it? Oh, they just give him permission. Oh,
exactly.
Well, that's what's way less interesting than what happened with Two Live Crew. So anyway, so that's the story on Weird Al. Coming up next, we have a lot of stuff I'm looking at my board here. I've got all of our ideas written down. I don't know where we're going to go next. Kirk has finally, I learned this morning, seen season 1 of Stranger Things.
I actually saw it a while ago. I just forgot to talk about it. And it's the first and as of currently only show I have ever truly binge watched. I don't have Netflix. I got it on DVD and promptly sat down and watched all 4 DVDs back to back.
And then on the flip side, I've also finally seen season 1 of Picard. Now that we're into season 3 now, so we may at some point go do a way too late review of these things, where we just kind of talk about these episodes to give you kind of a less legal heavy, more lighthearted review
we have had a couple
episode.
of real legal heavy episodes.
Yeah,
here.
We haven't done that in a while, so we got that coming up, and then we may go back and revisit the blockchain episode that we did. There's some new things coming up with NFTs and what's happening to that market. So lots going on, and I'm sure we'll come back from AIPLA, which we're going to in 2 months here, with a bunch of new ideas. So don't have any specific plans at this point, but hopefully you guys are continuing to enjoy what we're doing and putting out there. If not, let us know. And if so, let us know.
Yep.
All right, that's all for this time. We'll see you next time. Lauren, play us out.
The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by Lewis Rice LLC, its officers, directors, employees, agents, representatives, shareholders, and subsidiaries. None of the content should be considered legal advice. As always, consult a lawyer. This podcast was produced and recorded in St. Louis, Missouri.
Okay.
All right, there's something running back there. So.
Yeah, not much there. All right, here we go. 3, 2, 1. And welcome back to A Lawyer's Guide to the...